Art heard appeal in the matter of Expert Tooling and Automation Ltd and Engie Power Ltd.
Mr. Grant.
Good morning, my lady, my lords. I now turn to ground 6 of our grounds of appeal. My lady, that is covered in our skeleton argument at tab 3, at paragraph 71 through to 74. Your ladyship will see, if you turn to page 39 of the external pagination of the core bundle, the ground itself. I now come to present my submissions thereon. My lady, I perceive that ground 6, which is a ground, the first of our limitation grounds, is a ground which does give rise to rather wider questions about the precise nature of the cause of action pleaded upon and as to when that cause of action accrues. So even though it's shortly stated in the skeleton argument, there are quite deep questions that it engages. I shall attempt in the time available to excavate those questions. My lady, the point arose by way of defence, which was pleaded at paragraphs 21 to 24, where we see that the plea, this is I won't go to, I haven't got time, but it's tab 15 of the core bundle is the defence. The relevant paragraphs, as I say, 21 to 24, and the proposition that is advanced in those paragraphs is that the cause of action that was being sued upon arose or accrued on the date when the defendant was, to quote from the defence, contractually liable to make commission payments, end quotes. And it was said that that date was the date of the contract itself. My lady, by way of just some of the background, the very brief facts, contract 1 is the only contract which is engaged by this limitation defence, albeit because that's the largest amount of money that was paid out. It balks large in respect of the overall quantum of the claim. The facts, as your ladyship may recall, are my side, via its agent, signed the contract on the 28th of January, Engie signed it on the 8th of February, and the start date of that contract was the 1st of April 2016, so some 7 weeks thereafter. The claim itself was brought for the purposes of limitation on the 31st of March 2022, and the judge so held at paragraph 16 of his judgment. So it was brought 5 years and 365 days prior to or after the 1st of April, so far as that is a relevant date. The judge himself held at paragraph 103 that the cause of action had indeed accrued on the date of the contract, viz. The 8th of February 2016, and ergo by application of the 6-year rule by analogy. I don't dispute that, the analogy under section 36.
Mr. Grant, can I just ask a quick question by way of introduction, logistics? I see the live note is working.
Thank you, my lady, my lord.
Do we have a transcript of yesterday circulated to us?
Well,
We don't have them, but I think we're meant to have them.
that's an amazing fact. I don't know why it's not been sent to the people who are most important.
The only reason I ask that is because you're going understandably at a rate of knots, and I don't take shorthand.
No, quite.
So as long as I'm going to get a transcript of what I can see on the screen, I'll listen rather than try and write.
Could I don't know why the court, it's astonishing to me the court hasn't been sent it. I was sent it sometime last night. Opus will be given clear instructions.
I'm sure that was the arrangement. In fact, for various reasons, my clerk is not available this morning, so it's quite possible that it might have been sent.
I've asked my clerk to check.
But
anyway,
we haven't physically got it, put it that way.
That's
I'm
fine.
sure it will come through.
It's just you're going at such a rate.
Arrangements will be put in place instantaneously.
Thank you.
I hope.
That's all right. Well, I can see on the screen what you're saying today, which is really helpful today.
Thank you very much.
Anyhow, you had said that the judge dealt with this at paragraph 103, and he chose the date of the contract.
And said that 6 years ran from there, and therefore any claim in respect of contract 1 was statute barred, subject to the potential effect of section 32, which is of course the subject of my seventh ground. So the question for this court is whether or not the legal proposition of the defendant, pleaded in its defence and cleaved to in its skeleton argument for this hearing, viz. That the claim arose when so the defendant asserted it became contractually liable to make commission payments was right or wrong. We challenge both of those propositions, and we've challenged them for essentially 4 reasons, which I shall shortly state. Reason 1 is that the defence and the argument underlying it ignores the formulation by the claimant of its claim. And if one goes to the particulars of claim, and in particular paragraphs 24, 25, and the prayer, I don't go to them now, but the court will see that the claim that was articulated in the particulars was a claim in respect of the monies that were paid by the defendant to the agent. And the court may recall that in the recent decision in the Supreme Court in Smith and Bank of Scotland, Lord Leggett laid down yet again the essential proposition as regards the law of limitation, that in order to ascertain whether or not a claim is statute barred, one has to ascertain what the claim is, and that in turn requires one to ascertain what the remedy being sought by the claimant is. And the question of accrual depends on asking when all the facts have arisen which allow for the plea in respect of the remedy that the claimant has chosen. Now, we brought a claim for either money hadn't received or the equitable equivalent thereof in respect of the payment by the defendant to the agent. And it is common ground that the first payment made by the defendant to the agent was made by way of a payment on account, the 80% payment I've already adverted to yesterday, which occurred on the 30th of June. So well within the limitation period. And for the court's note, that was the defendant's own evidence, and it is there in the schedule to the defence at page 172 of tab 15 of the core bundle.
When did Engie become contractually liable to pay that amount?
Only after. Well, that's my next point. But only after the 1st of April, because can I come? That's one of my reasons. Can I come back to that? I will answer your lordship's question. I should say it's an important one. With respect.
On your first point, does that mean there's a different cause of action for every commission paid?
Well, in reality, my lord immediately also preempts a point that I was about to make. It's very, if I may say so, with respect, a very good point. But I'll come to it under reason 2, the second of my 4 reasons. Reason 2 involves going back to the nature of the liability in bribery, which I spent some time seeking to assist the court on yesterday by reference to the decisions in Hovenden and Mahisen and so on and so on. And your lordships and my lady may recall the reference in A.L. Smith L.J.'s decision of it's a remedy in disgorgement now, or a remedy in hadn't received. There are different formulations, but they are all founded on the right to claim the amount that has actually been paid by the bribe payer to the agent. More recently, it is right to say, but it doesn't in any way harm my articulation of this ground, that liability has been characterised as a liability to account for the amount of the bribe so paid, and one sees that in most recently Lord Hodges' judgment in Privinvest, paragraph 86, tab 44 of the authorities.
I thought I recalled as seeing that the underlying theory was that the price paid by the customer had been inflated by the agreement, or by the same amount as the payment of the commission.
That's the yes. I'm so sorry.
From the claimant's point of view,
that's the intellectual irrebuttable presumption. That's the intellectual framework which gives rise to the claim for money hadn't received, because as per A.L. Smith L.J. in Hovenden, adopted by Lord Diplock 70 years later, the amount of the bribe is irrebuttably presumed to be superadded, or the superplus, as Collins L.J. put it in gold in Grant, to the price. So the other alternative.
So why doesn't in the sense, if you're looking in terms of damages or equitable compensation, why isn't the damage suffered by the payer, the customer, when they have to pay the increased price?
Well, for this simple reason, because there's no contractual liability to pay anything on the 8th of February. It's a mere option. My client doesn't come under any contractual obligation to purchase a minimum amount of energy. Essentially, the contract allows it to buy whatever amount of energy it wishes to at a set rate.
I may not be making a point against you here, okay? So just be careful you don't sort of react too violently.
And I'm seeking to act in the most amicable and
good.
cooperative
well,
way.
as always. But if they are, I'm just putting a question openly, neutrally. If is one way of looking at it that the claimant suffers loss and damage for which it should be compensated when it makes the inflated payment?
Well, exactly right. That is
in which case, in a sense, every time, throughout the period of the contract, it's a continuing.
Well, if I may say so, my lord is ahead of me, because I was about to not take the court to, but just mention to the court the decision of Mrs. Justice Thornton in Surrey County Council and Lincolnshire Clinical, tab 39 of the authorities bundle, where her ladyship where there were overpayments made, but in a straight restitutionary claim, her ladyship held that every time the council made an additional payment that it shouldn't have made under a mistake, then a fresh cause of action accrued. Now, there are essentially two ways of looking at the nature of the cause of action. Way one is to say it is a restitutionary or a quasi-restitutionary claim which arises at the moment that the payment is made by the third party to the agent. The earliest date that could be is the 30th of June. Way two is to say that every time my client, the principal, makes a payment to the third party, which has, by irrebuttable presumption, and here, but by actual reality, as your lordship said yesterday, a payment under the contract, then a part of that payment has been overpaid because it constitutes part of the bribe, and a fresh cause of action accrues every time that sum is paid. But if way two is the right answer, then again, the claim under contract one is plainly not statute barred, because the first payment that was plainly made, and no one suggests otherwise, after the 1st of April, because that's when the contract went live. So whether you're looking at it in terms of seeking to recover overpayments by the third party, or whether you're looking at it from a sort of Hovenden or, in fact, Herstanger point of view, in one sense matters not, because it's still the case that my client, on either analysis, it's not really loss. It's not a loss-based claim, I should say. It is a restitutionary or quasi-restitutionary claim. It still leads to the conclusion that the claim is patently not statute barred. But if we just go back to way one for a second, what Goff and Jones says at tab 56 of the authorities bundle at 3316 is that, this will come as no surprise to the court, that the cause of action in unjust enrichment accrues at the moment when the defendant is actually enriched or receives a benefit from the claimant. On that analysis, of course, that can't be before the 30th of June, or probably before the actual first payment, if one looks at it under way two. And the second consequence, the second analysis that flows from that, is that the principal is not able to sue until the bribe has, in fact, actually been paid, because it is only then that the amount of the enrichment is irrebuttably presumed as against the defendant. I've got to move on. I hope you've got the pith of I think you've got the pith of my submission. The third reason I can take very quickly indeed, and that is that if one looks at all the relevant cases, and we've set them out in our skeleton argument, Boston deep sea fishing, I should say, the great case of the 1880s, Herstanger and Johnson itself, in each case, the interest is said to run, or required to run, by the order made by the court from the date of the actual payment. And that is obviously a very clear indicant of the date when the cause of action accrued. The fourth reason, which I can touch on relatively quickly, is simply this: that the actual factual or legal premise of the defendant's defence, i.e. the proposition that on the 8th of February, the respondent was, to quote my learned friend's skeleton argument at para 54, liable to pay commission to the broker under the brokerage agreements, is just wrong. It's just wrong because the liability on the part of Engie to pay commission is purely and simply consumption based. I spent a lot of time on this yesterday. It's not an upfront single payment which is payable irrespective of what happens. It's based on the actual consumption of the claimant, my client. If it consumes nothing and it has no obligation to consume anything at all, then there's no right of any sort to payment.
Well, there would be a sort of consistent approach, wouldn't there, following your line 1, line 2 point. If in fact the relevant cause of action accrued at the time that the customer made each overpayment, and what you're saying now is in effect it's when there is an adjustment of the commission from the, as I understand it, the way it works is that there's a anticipated payment up front and then an adjustment.
Quite.
So in reality it would all come back to the same point whichever way you looked at it.
There was a payment up front. It was a payment on account. It was an ad hoc payment because 80% is not there in the contract. It's just the way they went about things. They made it on the 30th of June. It was referable to estimated consumption. If there had been no consumption, then the payment would have all come back again. By the 1st of April, there was consumption of a sort, albeit only a minimal amount because of the 5 years that the contract had to run. But the critical proposition is that, the critical point is that the proposition underlying the respondent's response to this appeal and underlying their primary limitation defence is it just wrong, because the liability to pay commission on the part of the defendant was a factor and a function solely of my client's consumption, and their consumption did not start until the 1st of April and may never have started because there is no minimum obligation under the contract. And the fact that there was an upfront payment paid on the 30th of June is merely an arrangement, a mechanism between Engie and the agent, subject to later rearrangement depending on the actual consumption that has occurred. And my lady need only look at, and I just direct respectfully the court's attention to paragraphs 59 and 60 of Mr. O'Connor's witness statement, where he makes the position very clear that if the contract doesn't go live, i.e. on the 1st of April, which was the date it was due to go live, there is no right to commission, and that the only right to commission is a right founded on actual consumption, 5.6p per kilowatt hour actually consumed. That is, in essence, my submissions on ground 6. I shall spend the next 10 minutes on ground 7, which of course only arises if I lose or if I'm wrong on ground 6. My lady, the judgment in respect of ground 7 the relevant parts of the judgment are paras 119 to 127. We might look at those for the purposes of my short submissions on this. This is tab 9, which is of course the judgment, and it is paragraphs essentially 113 onwards. The actual gravamen of the judgment starts really at 119. Now, in response to the defence that I've outlined, a reply was served which sought to rely upon, amongst other things, section 32(1)(b). The prevailing authority, of course, is Potter. His lordship below quoted the relevant paragraphs of Potter at paragraph 122. What emerges from Potter, and in particular those paragraphs from the judgment of Lord Reed, is that there are 3 questions that arise when a claimant seeks to rely upon section 32(1)(b). Question 1 is, are there facts relevant to the cause of action, and what facts does the claimant rely upon? 2, were those facts withheld by the defendant from the claimant? 3, was that withholding or concealment intentional? My lady, very briefly indeed, the facts we relied upon as having been withheld are set out at paragraph 114 of the judgment. we said they had been withheld, going to part 2 or section 2 of the analysis, and we say they were withheld, it quite clearly withheld on the evidence in this case. And my lady, we say they were withheld in various ways. One, the contract itself, which I showed the court yesterday, involves Engie, the defendant, making a positive decision to limit the information that the claimant had about the nature or fact of the commission. And I refer to those bespoke, well, those boilerplate, not bespoke at all, those boilerplate words in the middle of the page, which we looked at with some care yesterday. That involved a decision by the defendant to disclose some things, but certainly not everything, and certainly not everything that was material to the cause of action. That was a positive decision made by the defendant because it had decided upon the boilerplate language and decided to utilise that boilerplate language in the context of contract 1. It was not just a positive withholding of information, it was, as I said yesterday, a positive misleading of the claimant. Will, as we now know. The second aspect of the withholding is that, as the court saw yesterday, clause 8.4 of the brokerage agreement involves a positive agreement between agent and supplier to keep the facts and matters within that agreement, which of course involves the commission mechanism laid out, confidential to themselves. Again, that was a...
It's not quite right. It's to keep it confidential, save as may be required by the agreement. And the agreement contains a term that says that the agent, I haven't got it in front of me.
Should be transparent and honest in its dealings.
Yeah. And so it's not clause 8.4 I don't think is as absolute as you have just described it, is it?
My lord, save for this fact, well, we're talking about concealment here by the defendant.
Sorry, am I right that 8.4?
You're right. You're absolutely right. You're absolutely right. But there are two answers to that. Answer 1 is that Mr. O'Connor realised that those clauses, the transparency clauses, were more honoured in the breach than in the observance. Hence his answers to the questions at page 81 and 82 of the transcript, which we looked at with some care yesterday. He realised, he knew that was just words on a page. They were never going to tell my client for all the reasons which I outlined yesterday. And the second answer to that is that may pertain to the agent's rights or obligations, but vis-a-vis the defendant, who after all is the claimant we are bringing the defendant we are bringing the claim against, it was an absolute obligation. And my lord, let me pursue that point if I may, very, very briefly indeed. If I could invite the court to pick up the supplemental bundle and to go to tab 42, which is at the moment, I suspect, terra incognita for the court. This is within the bundle where after the contract had been entered into, my client was seeking answers to questions. We pick it up at 42. I'm going to have to take this at pace, where we see a number of emails or a number of exchanges between my client and my learned friend's client, where essentially my client is saying, can you tell us what was going on? How much consumption, how much commission was being paid? That's 42. The answer that comes back at 43, tab 43, page 266, is we don't tell you. That's not a thing we tell you. That's Ms. Carter at the bottom of the page. We then at 45 try again and say, well, the broker who you've so kindly directed us to is now in liquidation. So we ask again at 45. The answer comes back again from Ms. Carter at tab 46, page 269. We do not disclose commission information to our customers. This is up to the broker, which was, if I may say so, a particularly glib answer when they knew the broker was in insolvency. and then there's the known industry practice. This is tab 46. We come back yet again at tab 47, page 20, page 270. And the answer that we finally get back at tab 50, which is the last tab in the relevant tab, is from Ms. Montero, another person. Following our conversation, I've reviewed the latest broker agreement in place with UW. As a consequence, I can confirm we cannot release information to the customer, as this would constitute a contractual breach of our obligations to UW. Again, it makes it absolutely clear that the policy of this company was to say nothing, even when asked to say nothing, and to hide behind the very contract that my lord just referred to. So what we say in brief is that there were facts relevant to the cause of action, 1. 2, which were in fact withheld. There's no doubt about the fact they were withheld. But 3, and critically, they were intentionally withheld because intentionally withheld by the defendant, my lord, because the defendant itself conceived its obligations under the brokerage agreement as essentially, we can tell you nothing. One may think that's a somewhat glib approach to take, and one may take a view on the underlying reasons for it. But it was an intentional decision on the part of the defendant. And finally, one might say that, Your Lordship, my lady will recall the decision of the House of Lords in Sheldon and Outhwaite, where every later concealment or intentional concealment by a defendant starts time running afresh. And one might well say that every time we get an email back from Ms. Montero or Ms. Carter of the defendant, when being asked relevant questions and where the shutters are being pulled down, there is a fresh, it's an intentional concealment because they've intentionally decided, no, we're not going to tell you anything. And we're going to hide behind the contract, the brokerage agreement. We're going to say go off and speak to the company they know is in liquidation, and so on and so forth. I say, and I'm going to sit down in 1 minute by reference to the clock to my left, because I'm conscious of my lady's quite important, absolutely right direction yesterday. We say that if even if we're wrong on ground 6, this is a classic example where section 32 1b should come to our assistance. And there is one final point touched upon by the court below, but in very opaque terms, which is, oh well, it's not just knowledge that you didn't have, it's knowledge you might have had. Well, in February 2016, as far as we were concerned, we had an agent who was working diligently and loyally for our benefit. Why should we start poking around asking questions? As far as we were concerned, we had the benefit of a fiduciary obligation which was being upheld by our agent. The only relevant period where constructive knowledge has any potential relevance is that 7-week window between the 7th of April, 8th of February rather, and the 31st of March, because that's the relevant date for limitation purposes, given the date that the claim was brought. My lady, at 10:30, unless I can assist the court any further, those are my submissions on this appeal.
Thank you very much,
Thank you, my
Mr. Grant. Mr. Lord.
Good morning, my lady, my lords. I'm going to say, subject to your ladyship, I'm going to say something very briefly about the nature of the appeal and the nature of the defence. And then I'm going to deal with each of the grounds in the same order that Mr. Grant dealt with them. As far as the appeal is concerned, as we all know, insofar as it's an appeal on the facts, which is round 7 and 8, that would only be successful if your ladyship was satisfied that the findings that the learned judge made were findings that no reasonable judge could have made. And as far as their appeals on the law, the question is simply, did he misapply the law? As your ladyship knows, the judge refused permission to appeal. We set out what he said in paragraph 14 of our supplemental skeleton.
So when you say ground 7 and 8, you don't mean ground 7 and 8, do you?
I beg your pardon, my lord?
Did you say as far What age is the application?
Sorry, I did say 7 and 8. Yes, I mean
6 and 7.
Yes, absolutely.
Sorry.
That's right, my lord. Lord Justice Snowden did give permission to appeal, and that's in the core bundle at 184. Grounds 1 to 4 are all grounds purely on questions of law. Quite understandably, there's no appeal against any of the judge's factual findings. There was some discussion yesterday about what exactly were the judge's findings of fact. For example, in relation to paragraph 187, where he talks about the flavour. We can come back to that, but what he did plainly find as fact was, first of all, that the scope of the duty did not extend to disclosing the amount of the commission, how it was to be funded, or the arrangement.
It's not a finding of fact, surely. The scope of a duty is not the finding of
Well,
fact.
it's based on, well,
I mean, a fact is, you know, A hit B,
yes,
or B had this state of knowledge. But
yes,
the question of what is the scope of a duty, surely that's not a finding of fact. That's the whole concept of what a duty is and how wide it is and what it requires somebody to do is a question of law, surely.
I take that, my lord, but of course it's based on the facts as they were presented to the judge during the course of the trial.
Well, the scope,
we'll
of,
look at
the scope of a duty may be fact sensitive,
Yes.
it's sensitive to the facts of a particular case, I get that. But the actual question or the answer is surely a legal question.
I accept that, my lord.
And Mr. Lord, you had just said that grounds 1 to 4 were questions of law.
Yes.
So I think that you accept that too. It's the question of law based on the facts.
Yes, and I'll come to ground 1 in a minute.
Oh.
He did find as a fact that neither Mr. Forster nor Mr. Gaisley were vulnerable or unsophisticated. And that's paragraph 170. And he did find as a fact that there was informed consent. That's paragraph 224.
I may start making some similar observations, I think. I mean, the fact, I mean, whether somebody is vulnerable or unsophisticated, I suspect is an evaluative judgment. It's not actually a fact. It's an evaluative judgment of, you know, a person. You ask yourself the question: is that person unsophisticated? There's no fact. You base your judgment, your evaluative judgment, on what facts are relevant to that question. And then the second point is informed consent. I mean, you find as a fact what the person was told, and you find as a fact what the state of their knowledge was. But the question of whether it's informed consent is a legal question. You know, what amounts to informed consent is actually a legal question, isn't it?
Well, my lord, he did find that there was informed consent. Just leave on one side for a moment if that's factual finding.
Yeah.
So
what you're trying to do is you're trying to put as many findings into a box marked fact.
Yes.
To then say we can't touch them.
Yes.
And I'm sort of.
You're telling me not
being
to.
told I can't play with sort of toys. So, you know, I am questioning actually whether you are correctly characterising some of these findings as fact we can't touch.
Well, my lord, let's move on. We can revisit it if necessary when we deal with the specific grounds. But the overarching point I would make is that His Honour Judge Saffman had the benefit of seeing the witnesses.
Yep.
He is the trial judge. Whether or not, in reaching his findings, he had to carry out evaluative judgments of whatever kind, he was the person who was best placed to decide these matters.
Yeah, so that, for example, if Mr. Gaisley, I think it is, said, I don't know whether he did ever say something like this, but I didn't appreciate, you know, I may have been sent that, but I didn't appreciate it meant X. A finding by Judge Saffman as to whether he did in fact appreciate it or not would be a finding of fact as to his state of mind.
Yes. Yes.
I'll accept that. We'll go back to agreeing on that. Okay.
The other point we make, this became apparent yesterday, is, my lord, in your permissions for appeal, granting permission to appeal, you refer to it as a common law claim for money had and received.
Yeah,
And yeah, we quietly made the point that that's not
Yes.
right.
yeah, well, I things have moved on a little bit, and you appreciate it. Sort of the question of what the nature of the claim actually was is one we've heard quite a lot about. So yes, if I don't think anybody in this court is going to be bound by what I mischaracterised or said on that application for permission to appeal. You don't need to worry about that from my perspective anyway.
But my lord, can we just briefly look though at how the claim was pleaded? Because my learned friends referred to it a few times, but never took the court to it. It's in the core bundle, tab 13, page 152. And I just want to highlight what we submitted the relevant paragraphs. Paragraph 6, one sees the fiduciary duties. Paragraph 16 are the allegations as to what the defendant knew, namely that Utilitywise acted as a broker or agent and owed fiduciary duties. Paragraph 20 is the allegation that there was no informed consent. Paragraph 22, it's made clear that it's a half-secret case. Then the claim, paragraph 24, is a claim for money had and received. And as your ladyship knows, in our submission, that's not the case for a half-secret. And then paragraph 25, alternatively, all profits or other benefits were procured by the defendant's payment of commission in breach. Accordingly, the defendant is liable to account. That claim was not being pursued. That's a claim for account of profits. Of course, there was no profit made as a result of the commissions by my clients. And then paragraph 26, in the further alternative, by paying the commissions, the defendant intentionally and wrongfully induced Utilitywise to act in breach of its duties and obligations to the claimant. In the premises, the defendant is liable in damages. The loss caused is at least equal to the amount of the commission. Well, my lady, at trial, a claim was pursued for wrongfully inducing a breach of contract, but that's not pursued on this appeal. Now, that's the pleading. The claim at trial was an accessory liability claim.
26 is a claim for intentionally and wrongfully inducing a breach of fiduciary duty.
As well.
Yes.
Yes. And the claim at trial was an accessory liability claim for equitable compensation, equivalent to the amount of the commission. As a result, it was said, of Engie procuring the broker's breach of fiduciary duty, but with the important caveat that that accessory liability did not require dishonesty. So that's where we were at trial. Now, if I have understood my learned friend's submissions, it's put somewhat differently. It's now alleged to be a sui generis equity liability that merely requires, first of all, knowledge of the agency, and secondly, the payment of a commission. It's alleged to be a primary liability, not an accessory liability, and it is said that it only differs from a bribery or fully secret commission claim in the remedies available, namely that rescission is not available as of right. I'm not altogether sure, but I thought he got as far as to say it does not even require any act of procuring a breach, although he did, when one looks at the transcript, when you get it, he did frequently refer to it as a liability for procuring a breach of duty. What is also not clear is whether or not it requires a fiduciary duty, or knowledge of a fiduciary duty, and knowledge that that duty has been breached. Because the way Mr. Grant put it is it simply requires knowledge of the agency.
Well, if you know somebody as an agent,
Yeah.
I think you can be taken to know that they owe fiduciary duties.
That may be.
Well, I mean, it must follow. And like in this, and like every other area, if you know somebody's acting as an agent, the fact you don't consciously say, oh, yes, they owe fiduciary duties because I'm a lawyer, that surely doesn't matter. I mean, if you know they're an agent and they owe fiduciary duties, that, at least if that's the requirement, that would be met. I mean, I quite understand the question about whether there's a breach or you know about the facts which amount to a breach is a completely different thing.
Yeah.
But you don't have consciously to have had in your head that somebody owes fiduciary duties if you know they're an agent, surely.
Well, I don't think it matters for today's purposes, but there are, in my submission, some circumstances where you can have an agency which is not a fiduciary relationship. But I don't think we need to get into that today. But
And nobody's suggesting this is something
no. But in effect, what Mr. Grant's submissions amount to is that there is no distinction other than in connection with the remedy, which we're not concerned, but there is no distinction whatsoever between a claim in respect of a bribe and Lord Justice Tuckey's halfway house. And that is completely contrary, and we'll look at these in due course, but that's completely contrary to Herstanger and to Wood, and everything that Lord Justice David Richards says in Wood, where he's drawing the distinction. He analyses what is required for a bribery claim. And we had a lot of debate about that because my primary submission was you required a fiduciary duty. And he held, no, you don't. For a bribery claim, there has to be a duty to give duty of loyalty and a duty to give disinterested advice. But he clearly also drew the distinction between a bribe and a half secret commission. And that distinction is something that Mr. Grant now submits does not exist. Anyway, my lord, can I come on to ground one, which is concerned with the scope of the duty? And it's dealt with in paragraphs 147 to 195 of the judgment. Now, if one looks at the judgment in the core bundle, paragraph, I'm just going to whiz through or give your latest references. Paragraph 3, there is reference to the fact that expert tooling had used a broker before. And then paragraph 8, he just refers to expert tooling. Paragraphs 27 and 28, he talks about Mr. Forster and his experience. Paragraph 29, Mr. Gaisley, whose evidence, by the way, was that he had been arranging energy contracts for 4.5 years. That's in the transcript supplemental bundle, page 50. Paragraph 31 and 32, he says a bit more about expert tooling. And then paragraph 170, I've already referred your ladyship to. That's where he finds Mr. Forster and Mr. Gaisley were not vulnerable or unsophisticated. Paragraph 171, he refers to 2 of the county court cases. And paragraph 172, he says that even if unsophisticated, no reason for the broker to know that. He deals with the telephone call with Mr. Forster, and one has to go back in relation to that. Paragraph 52. And importantly, this is not the first conversation that Mr. Forster has with Mr. Jackson. Indeed, he said that he thought he'd spoken to him previously. He said 10, 20, 30 or 40 times. That's page 21 of the supplemental bundle. Paragraph 53, one sees that Mr. Forster was happy with the charges. Paragraph 54, and we looked at that yesterday, he runs through the script and he's told that the commission will be added to the...
Well, he's not. That's not what it says.
in paragraph 54. He's just quoting from the transcript.
I know, but it doesn't say in the transcript that the commission will be added to the price, does it?
We do get paid a commission from the supplier and as part of your energy package.
Well, that's the bit that's gone.
Well, let's look at the three passages where he deals with this. There's 54, there's 187, the claimant knew more than Mr. Gaisley, knew what Mr. Forster knew, what was told about him. Commission is recorded at paragraph 54 above. It is not the clearest description, but in my view, it gives the flavour that the commission is part of the unit cost.
Right, now that last bit, it is not the clearest description, it's simply the judge's evaluative view of the fact of what was said as recorded in the transcript.
Yes.
And we can take as A, it's not finding a fact, and B, it's something that we can look at for ourselves.
Yes, and if you want to, you can listen to the audio, which the judge did.
I don't think it's going to get clearer from the audio, is it?
Well, I mean, nobody's saying that the judge does
The point my
report.
Lord's just put to you is that what's at paragraph 54 is very far from as clear as you described it. I mean, he didn't say, by the way, the commission will be added to the price you're going to pay for the...
No, he said it will be added to the energy package.
Well, I don't think it even says that. It's garbled, and if you compare it to the other transcript, which apparently was running through the same script, they're very different points.
They are because less is said to Mr. Gaisley. I accept that.
Well, I'm not sure. The same phrase is used, but it clearly links to what follows, which is, I think, a bespoke manager for you.
Account manager, yes.
Yeah.
And then just to finish this, 204 in the judgment, the claimant was told that commission was payable. It was not told how much. Mr. Forster was told that it would be funded as part of the energy package. At the same point. Back to...
And he would say that that is arrived at, as if you go back to 54, if you take out the and,
yes,
we do get paid a commission from the supplier as part of your energy package.
yes.
Take out the and.
Yes, and when you factor that in, we'll come on to it, but when you factor in what is said on the notifications of all the contracts and the prior contracts, that we may be paid a commission, it would be added to the unit rate. That is all part of the parcel of knowledge that is passed on to the customer. So that they are told on the face of every single contract that it may be added to the unit price.
So where is it?
That's on the contracts.
Show me that.
So if you go forward in the core bundle to 184, 184 just above the second hole punch, if you use a third-party consultant or broker to negotiate your contract, the prices quoted may include commission due to them. So when you add that to what is told in the telephone calls, and you add in, and we'll look at this in due course, paragraph 84 of the Court of Appeal in Johnson, they are saying that contrary to the facts of the motor dealer cases, if the agent is not being paid by anybody else and can't be expected to be paid by anybody else or get his money back from anywhere else, then you should expect that you will be paying for it. And that is where the additional services, which my learned friend simply dismissed, but that's where they come into consideration. They're referred to in paragraph 55 in relation to Mr. Forster. There was some discussion about what additional services the underwriter would provide. and there's referred to an account manager, software, and a smart meter. And that is why it is the broker who sets the commission, because the supplier has no contact whatsoever with the customer. All the supplier is concerned about is the credit rating. Will the customer be able to pay? What the supplier doesn't know is what additional services are being provided. And the additional services in relation to Mr. Gaisley are referred to in paragraph 60 of the judgment. Mr. Jackson told Mr. Gaisley that Utilitywise would do an energy audit and would help complete applications for feed-in tariffs, which Mr. Gaisley thought would all be handy. Back to paragraph 67.
We have a slight problem in understanding what these services are, because we haven't seen any document which apparently should have been provided with the terms and conditions, which sets out what services.
I accept that, but nobody found the welcome pack, for example. And I should point out that Mr. Gaisley said that as far as he was aware, no additional services were provided. But it's clear that they were offered.
But what evidence do we have as were there any arrangements made to facilitate or for the provision of services, or even to have a discussion about them?
We don't know, my lord. There are no emails that have been disclosed between the broker and Expert Tooling before September 2017. And that's recorded in the judgment. So the answer is, all we do know is that additional services were offered. And it was said that they would be provided.
Before September 2017?
Yes.
Because they weren't available, I assume.
Well, yeah, we wouldn't have them.
But they weren't disclosed because...
No, and there was no disclosure from the claimant of anything, of any emails or whatever, before September 2017.
Was that because there was a decision taken? They
No. We pressed for them, and we were simply told they couldn't find them. They couldn't find anything before September 2017, which caused some discomfort in relation to things like the earlier letters of authority. I don't think any of this matters, but at the trial there was a Mr. Bland who signed the original letters of authority, and Mr. Forster's evidence was quite confused as to when he took over from Mr. Bland, and there was just nothing from which the court could discern quite what was going on and how the relationship between Utilitywise and Expert Tooling developed.
Well, it's equally consistent with just nothing going on.
No, because we know that there's plenty of emails after September 2017, but nothing before.
Right, but are the emails after, I mean, are they just related to pricing, or are there lots of other things?
And different contracts and whatever. Well, there's nothing that's relevant to the negotiation of these
No, what I'm saying is, are there after 2017, were there lots of emails offering the sort of services that we've just been debating?
My lord, not that I can recall, no.
There weren't, my lord.
No, my lord, but I mean, your lordship asked me what additional services and where is the evidence, and the answer is the only evidence is in the transcript of the phone calls. That's where we are. But the fact of the matter is, whether or not these services were provided, is that they were offered and they were part of the deal. What there aren't, for example, are emails from Expert Tooling says, well, what about this? What about this that you promised? What about the audit? What about helping us with the fit application? What about, there's nothing. Back to the judgment, paragraph 68, the judge recalls that Mr. Forster says, Mr. Gaisley says he was happy with the unit prices And that's the important point, or an important point, my lady, that you get out of these telephone calls, is that at the end of the day, all that expert tooling was really concerned about was how much am I going to pay for this electricity? And they were told that, and they agreed to it. And indeed, they paid it. In paragraph 69 to 70, he does not deny that he was aware that Utilitywise would be charging a commission. His point is that the stage was he was told that the commission was paid by the suppliers would be added back onto the energy cost. He assumed that commission would be paid by the defendant simply as an overhead. Furthermore, his evidence is that he did not know how much the commission was. He was not told, but he acknowledges he never asked. He recognised, when asked by Mr. Lord, that he had no evidence upon which to base his assumption that commissions would be funded by the defendant rather than funded by the claimant through the unit cost. He acknowledged that nothing in the paperwork suggested that this was the case, and neither could it be inferred from anything Mr. Jackson said to him. Indeed, he conceded to Mr. Lord that his assumptions as to the funding of commissions was illogical. Now, my lady, just pausing there, one has to be very careful in this context about what the claimant expert tooling knew. It is not sufficient for expert tooling, or indeed any principle, to say, well, I didn't understand any of that. I didn't listen. I wasn't told. If somebody's assumption is illogical, then they cannot pray that in aid of lack of knowledge. And at paragraph 199 of the judgment, I'm sorry to skip around, the judge makes a point. Furthermore, the assumption that commission will be funded by the defendant is not supported by information in the public domain. Yet further, I would suggest that the fact that commission was mentioned by Mr. Jackson to both Mr. Forster and Mr. Gaisley would be said to bring it with it an implication that the claimant would be paying it. If A tells B that A's services will result in a payment to A, it may well be that B would assume that he is being told because he is expected to pay. If he is not, then the information is likely to be of considerable less interest to him. So, my lady, when one steps back, in effect, what the judge is saying is that the claimant should have appreciated, first of all, it conceded, it knew that commission was being paid. It should have appreciated that it was paying it, and it should have appreciated that it was paying it as part of the unit rate, which it was happy with. Now, my lady, just to clear up a few other background factual matters, the broker's terms and conditions, we don't need to go back to those. My own friend took you to them. They're referred to at the bottom of all the emails. They're also referred to in each of the letters of authority, which are in the core bundle 203 to 208, and therefore, in my submission, must have formed part of the contract. And indeed, Mr. Forster accepted that in evidence. That's page 10 of the supplemental bundle. And my lady, it's important to realise that we are not dealing here, as far as the agent is concerned, with a car dealer. Utilitywise was a large business. It was a PLC based on AIM. Now, my lady, can I now deal with can I come on and deal with the side letters?
Do you mean Utilitywise, or do you mean Tooling was a large business?
No, I mean Utilitywise. Utilitywise was a PLC. Can we just look at the side letters, which are in the core bundle? The first one is at page 229. and you'll see, I'm sorry, that's not the first one. The first one is at 223. And 223.3, EDFS wished to incentivise the TPI to support its ongoing sales activities, targeting the acquisition of additional electricity supply sites in the period July to December 2015. So that is not relevant to any of our contracts. If we go on to the second one, which is at 229, that is the period July to December 2016. So that is not relevant to the first contract, the substantial one. And importantly, it's clear from clause 4 that the incentive is in relation to introducing additional new sites and customers. For each of contracts 2, 3, 4 and 5 related to the same site as contract 1, the Mercantile Road site. And that's why, when you look at the table at the back of Mr. O'Connor's witness statement that my learned friend took you to yesterday, 1.183 of the supplemental bundle, the commission paid is always the 80% up front. Of course, if the campaign commissions had applied, it would only be 40%, with 40% going to be offset against the 2 million. So,
Is it right under the slide letters that it only relates in any event to contracts with a start date either in that year or within the next year?
yeah,
So the fourth, second, fifth.
wouldn't apply anyway. No. So they are a complete red herring. As far as the contracts are concerned, we've looked at them. You've seen the notification on each of them, and also on the prior contract. And the prior contract wasn't in the bundle, but it has been added. I think it's page 10 of the short ancillary bundle. Okay. Yes, it's pages 10 and 11 of the ancillary bundle, and it has precisely the same notification on the face of it. And of course, as far as the word may is concerned, I just remind your ladyship of paragraph 189 and what Lord Justice Tuckey says in the first hanger about may. It's sufficient to put somebody on notice. And of course, here one has the notification, and one also has what they are told in the telephone calls. The lady back.
That's a wrong reference, I think. Paragraph 189, you said, of her stanger. There isn't a paragraph 189.
I'm sorry, I'll find it. I'll find it in due course. Back to the judgment. Paragraph 181. Oh, I'm sorry, my Lord Justice. 189 of His Honour Judge Saffman's judgment, referring to paragraph 49 of Hurstanger.
43.
43. I'll get there eventually. Paragraph 181 of the judgment, which is in the core bundle at page 132. I have not heard any evidence that the commission paid to Utilitywise was an exceptionally large sum, or was anything other than the customary rate of reward in the market. Indeed, such evidence as I did here suggests the opposite. And that's important, my lady, because...
Sorry, can I just rewind to paragraph 43 of Hurstanger? I mean, he's dealing with a different point there, isn't he? Sorry, I've just lost the thread of what you're submitting here. You're dealing with ground 1 at the moment, which is scope of a duty of a fiduciary. And Lord Justice Tuckey's paragraph 43 talks about whether telling somebody something will happen will negate secrecy. It's a completely different point,
No,
isn't it?
I accept that, my lord. I was just
You're not suggesting, are you, that, or are you, that because, or that what was said in this document at page 10 of this little supplementary bundle, the if you use a third-party consultant to negotiate your contract may include the commission, that the agent was no longer under a duty to obtain the fully informed consent. I mean, that's not what
No.
Justice Tuckey's dealing with. Sorry,
No,
I've lost the thread of where your submissions have gone
my
on this
lord,
point.
it's as always entirely my fault. I was going through the judgment, and I just wanted to pick up the relevant passages in the judgment. What Lord Justice Tuckey says, and what His Honour Judge Saffman refers to, does relate to the contracts and the prior contracts in the use of the word may. It does not specifically relate to ground one, which is the point your lordship's putting to me.
Yeah, sorry, I'm
The
just
scope.
in.
No.
I thought you were on ground one, so I'm just in
No,
mentally ground one mode at the moment.
My mistake.
Right, okay.
My lord, I was then going to paragraph 181 of the judgment. Where the judge finds that the rates were not exceptionally large or anything other than the customary rate of reward. And then, my lord, just to pick up on what I've mentioned earlier, in my submission, Engie Tooling should have appreciated it would have to pay the broker who was acting for it. And my lord, one gets that from paragraph 84 in Johnson, paragraph 199 of the judgment, which we've looked at, and paragraph 224 of the judgment in relation to the additional services. Lord, then, in relation to the judgment, as my learned friend said yesterday, there's continual mention in the judgment that if expert tooling wanted to know anything more, all it had to do was ask. And just for your ladyship's note, it's paragraph 64, 69, 119, 126, 177, 186 and 195.
But that, yeah, and
I'll come on to where that takes us, my lord. Then, just before the short adjournment yesterday, Mr. Grant was taking you to Mr. O'Connor's evidence about he wouldn't have expected the broker necessarily to disclose the amount of the commission. But when I jumped up at 1:05 for the first time, I pointed out that he does say clearly that if asked, he would have expected the broker to say what the amount of the commission was. And that's in the supplemental bundle at paragraphs 82C and 87F. And we'll look in a minute at what Mr. Justice Simon said about that in FHR. But the customer is an experienced business dealing with important contracts that it's dealt with for a number of years. It's not an individual purchasing a motor car. It's not a pub landlady who was found to be sophisticated in Dartford Pig. And it's not a retired person working pro bono for a lawn bowls club, which was the case of Leicester Bowls. And my lordship, one has to also bear in mind the nature of the energy market, where the rates will fluctuate on a daily basis. So there isn't a real element of urgency about that. So, my lord, on ground one, can we look at the law? Now, in Hursthanger, which is tab 23 of the authorities bundle, page 484. I think we may not need to turn it up. Paragraph 36. Well, Justice Tuckey says there is some doubt as to whether the agent's duty of disclosure requires him to disclose to his principal the amount of the commission he is to receive. And he refers to Bousted, where the principal leaves the agent to look to the other party for his remuneration, or knows he will receive something from the other party. He cannot object on the grounds that he did not know the precise particulars of the amount paid. Such situations often occur in connection with usage and custom trades and markets. When no usage is required, however, the principal's knowledge may require to be more specific. The cases cited support those propositions. Here, I think the requirement is more special. Borrowers like the defendants come into the non-status lending market and likely to be vulnerable and sophisticated. A statement of the amount which their broker is to receive from the lender is, I think, necessary to bring home to such borrowers the potential conflict of interest. So Lord Justice Tuckey there is talking or relying upon the fact that in Hursthanger, the borrower was unsophisticated and vulnerable. Then if we can look, my lady, at Medstead, which is in tab 34 of the bundle of authorities. If we can pick that up, paragraph 34, and the Lacey saw this yesterday, paragraph 35, where Justice Longmore refers to Hursthanger. Then it goes through the passage in Bousted that we've just looked at, and the case of Macmillan, and then I think we can pick it up again at paragraph 42. And this is where I think my learned friend says he was at pains to point out that he didn't quibble with the decision, but he does go as far as to say that paragraph 42 is wrong. He says you should merely look at the disclosure and the question of consent. But what Lord Justice Longmore says is that even if the relationship of Medstead and his clients was a fiduciary one, the scope of the fiduciary duty is limited where the principal knows his agent is being remunerated by the opposite party, which in my submission is our case. He refers to Bousted, and then he says, he makes the same point the trial judge does. He can, of course, always ask, and if he does not like the answer, he can take his business elsewhere. Bousted does add that where no trade usage is involved, and no usage was alleged in the present case, the principal's knowledge may require to be more specific. In Hursthanger, the court held that it did need to be more specific because the borrowers were unsophisticated. The contrary is the case here. My submission, same in our case. And then I think 45 he refers to you. And then 46, which Lord Justice Zacaroli pointed out, I would therefore hold that on the facts which the judge found, Medstead was not under a duty to the clients to disclose the exact amount of the commission it was receiving, or to put the matter another way, to the extent that Medstead was the fiduciary of its clients, it was not a breach of that duty for it not to disclose the amount of commissions it was receiving. Now, my lady, that refers in effect to the overlap between ground 1, scope of duty, and ground 2, informed consent. Because we accept, as indeed the judge did, that the factual matters that feed into those questions are often, if not very similar, the same.
In your case, is there any daylight between the two questions? is the same factual question answered
Yes.
in the same way in both parts?
Yes,
so
I mean,
do we need to really concern ourselves where this fits into the analysis then? The question of informed consent and whether it's fully or not is a critical question to answer at some point in this case.
it is. I mean, I don't mind if I win on ground 1 or on ground 2. And I accept that very similar considerations arise in relation to each of them. When pushed, Mr. Grant, when he was asked, well, why do you say Lord Justice Longmore went wrong? His only answer was that fiduciary duties tend to be negative, forbidding something. And I think what he was trying to say is, therefore, you can't build back, you can't limit them. They are just there. But that's not what Lord Justice Longmore's saying. He's looking at it and he's saying, he's asking the quite sensible question. Did these brokers owe a duty to disclose the amount of the commission to these sophisticated lenders who knew that a commission was payable? Answer, no. And in my submission, the same question posed in our case. Did Utilitywise owe a duty to disclose to this company, Expert Tooling, that had entered into energy contracts for a number of years, was sophisticated, wasn't vulnerable, knew what it was doing, knew that a commission was payable, should have assumed, any other assumption was illogical, should have assumed that it was paying it, and indeed was paying it as part of the unit price, and was happy, importantly, was happy with the unit price, which wasn't extravagant, paragraph 181, was happy with the unit price. And one sees this from the transcripts, Mr. Jackson gives out his telephone number, says call me whenever if you've got any questions. And so it was quite clear that if Expert Tooling wanted to know any more, all they had to do was ask.
Sorry. We've been looking at the authorities, which sort of seem to be premised upon some commentary in Bousted.
Yes.
We haven't actually gone to Bousted. If you actually go to what Bousted says, which I think is in the bundle,
It is.
I think it puts a slightly different cast on things, if I may say, or I'd quite like to hear your commentary, because it very much suggests that the comments that you've been placing reliance on are made in the context of a well-established trade and custom type of market. And the court would be very slow to place much reliance on that unless you've given some pretty clear evidence about the market and the trade and custom. I think the equivalent, it's in tab 54, I think.
Page 1448, is it, my lord?
Yes, well, 1448 is disclosure and consent, paragraph 639, yes. Which is more seems to be much more general, and in the middle of it says, for example, in the 6039, the burden of proving full disclosure of a conflict of interest and obtaining consent lies on the agent. It's not sufficient for the agent merely to disclose the existence of an interest or to make such statements as would put the principal on inquiry, etc., which I think is the sort of conventional approach. I don't know whether you place any more reliance on 639. That's not, I think, the paragraph that was being referred to.
No, 6086.
Exactly. It was 6086, which is a few pages on. And in 6086, it's actually talking about first of all, that a principal is aware that an agent is receiving some sort of commission is likely to preclude the principal from rescinding the transaction as a right, but you might get rescission. And then where the contract between agent and principal provides the agent may receive commission or other remuneration from the third party and states that where that happens the amount will be disclosed, it's likely to be misleading conduct not to disclose. And then a little bit further down is the passage I think that is really being referred to in the authorities, as I can see it. It's if the principal knows the agent has been paid such a commission and consents, the principal can't afterwards claim against the agent. Similarly, where the principal leaves the agent to look to the other party for remuneration, or knows that the agent will receive something from the other party, the principal can't object on the ground that it did not know the precise particulars of the amount paid. Such situations often occur in connection with usage and custom of trades and markets. The courts are generally most reluctant to recognise any custom or market practice that is asserted in relation to undisclosed benefits received by an agent. But nonetheless, the existence of the practice may provide some circumstantial evidence of consent on the part of the principal. And that last bit is very clearly slanting the commentary to say, look, the basic rule is it's for the agent to make full disclosure and obtain consent. And it might be that in a particular trade or market, you might have a practice that provides some circumstantial evidence from which you can infer consent. That's quite a long way from our case, isn't it?
My lord, and quite a long way from Medstead, of course, because Medstead there was no trade custom or usage.
So, I mean,
My lord, I don't read that paragraph quite as your lordship does. I don't read the passage of such situations often occur as being at all necessary in relation to what is said in the 4 lines before. If the principal knows that the agent has been paid such a commission and consents, the principal cannot afterwards claim against the agent. Similarly, where the principal leaves the agent to look to the other party for remuneration or knows that the agent will receive something from the other party, the principal cannot object on the ground that it did not know the precise particulars of the amount paid. Absolute statements. Then, just by way of example, such situations often occur. But it's not saying they only occur, and there must be a trade custom or usage. The principle is that the agent knows, the principal knows that the agent's been paid a commission, or the principal leaves the agent to look to the other party for remuneration.
I'm not sure how I reconcile that second part, which doesn't actually have an authority attached to it, of that first sentence, to the earlier paragraph, which makes the point that it's really it's for the agent to obtain fully informed consent.
Well, can I just ask this as well, linked to that? Isn't this dealing in this section with bribery, i.e. fully secret commissions only? The earlier passage is dealing with the question of fully informed consent to get out of a breach of fiduciary duty. But this section is talking about bribery.
You may be right, because I'm just looking back to the heading, bribes and secret commissions.
Yeah.
6. Oh,
But again, if it applies to bribery, in a sense, in relation to half secret, in my submission, there's no reason why the same premise shouldn't apply. If you leave it, if you know that the agent is being paid a commission, which Expert Tooling did, and if you know you're not paying it, as the Court of Appeal say in Johnson, the reasonable expectation is that the other party will pay it. Now here, the knowledge was even greater because of the notification on the contracts and what is said in the telephone calls. So that in my submission, the only logical assumption, and it's the logical assumption that matters, and I'll come on to that when dealing with ground 2. The only logical assumption is that the broker, Utilitywise, is being paid commission. by the supplier, and as stated on the contract, it is being added to the unit rate and therefore funded by expert tooling. Now, the question for ground one is, in those circumstances, can it be said that the scope of the agent's duty was to disclose the amount of the commission? And in my submission, the answer is the same as the answer Lord Justice Longmore gave in Medstead, which is no.
But I think the point is you're just going from the wrong end of the telescope. The scope of the agent's duty is not to put himself into a position where he has a conflict of interest unless he obtains the fully informed consent of the principal.
Yes.
So the scope, I mean, this is the problem with using this word scope. I mean, the duty is, I thought, clearly, if you're an agent, you can't act in a position of conflict without fully informed consent. So the question is, what's fully informed consent? Isn't the judge just wrong to sort of introduce the wrong end of the telescope by using the word scope? And other than Lord Justice Longmore, nobody else sort of seems to go at it in that way. And that's really, I think, the argument.
My lord, one has Medstead, and my Lady Justice Asplin was part of that panel, and it stood as the law. And in my submission, there's no reason for departing from it. One can reach precisely the same conclusion, I fully accept, by dealing with it under informed consent. But these are two roads to precisely the same destination. And there's no reason in my submission for simply throwing out Lord Justice Longmore and saying, well, it doesn't matter because we can look at it from the other end of the telescope. The fact of the matter is, and it's referred to in Bousted as well, the fact of the matter is that it's clear authority for the fact that the scope of the duty, if the principal knows of the commission and doesn't ask, the scope of the duty does not extend necessarily. I accept it's a factual question, but does not necessarily extend to disclosing the amount.
So, I mean, just right, you can have as big a conflict of interest as you wish as an agent. You can make arrangements which are as conflicting as could possibly be arising from the payment of a commission. But provided you simply say to the principal, I'm being paid a commission, that's an end of it.
Well, my lord, it's...
Is that it? I mean, your submission, I think, is literally, if you use the word commission, everything is outside scope. I mean, it's just whatever the agent has agreed, however big the structure of the commission, however big the conflict, the fact he badges it as a commission and says, I'm earning a commission, that's it, game over.
No, my lord, and I don't think Lord Justice Longmore would say that.
I'm sure he wasn't.
If, for example, in Medstead, he'd found that that the principal was unsophisticated and vulnerable, I suspect he would have reached a different conclusion.
But you say if you are sophisticated, that's it, game over.
No,
provided somebody says at some point commission to you and you don't kick off, then...
No, my lord, it's not an all or nothing. It's a question. It is an evaluative judgment based on the facts as to whether or not it falls within scope. And I fully accept that the same considerations as, and we won't revisit them because we've revisited them already, but the same considerations that apply to whether or not informed consent were attained apply to the scope. And the person who is best positioned to make that judgment is always, with the greatest respect to all appellate courts, but is always the trial judge. So the only question really in my submission that matters for my lady and your lordship is whether or not the judge went wrong in law, in what he was considering. And in that respect, if one goes back to the judgment, in paragraph 147 of the judgment, he acknowledges the conflict paragraph 149 to 154, he refers to and clearly bears in mind Medstead and Bousted. Paragraphs 154 to 157, he refers to the concepts of sophistication and vulnerability. And then paragraphs 173 to 176, he refers to the other matters that he took into consideration, in respect of which he gained assistance from His Honour Judge Headley in Leicester Bowles. And it's not suggested, as I understand it, it's not suggested that he took the wrong matters into consideration or failed to consider something that he should have done. Then in paragraphs 179 to 181.
I know you wanted to go, you took us to 149, but can you just decipher paragraph 148 for me?
148.
Yeah, lead it.
This case is no different. If he puts himself in a position where his interests conflict with those of his principal, then to the extent that the nature of that conflict is within the scope of his
Okay,
faculty.
so just pause there. If he puts himself into a position where his interests conflict with those of his principal,
Yes.
then to the extent that the nature of that conflict is within the scope of his fiduciary obligations, if his interests conflict with those of his principal, that is
Yes.
a breach of fiduciary duty. So I don't really understand to the extent the nature of the conflict is within the scope of his fiduciary obligations, which is where he introduces this concept of scope. I don't understand that phrase at all.
Well, there he's going on to consider informed consent.
Yeah, so in other words, if he puts himself in a position where his interests conflict with those of his principal, then the agent is in breach of his fiduciary obligations unless the principal had given informed consent. And then I don't understand the last bit either. I mean, if that's all that paragraph had said, that would be entirely conventional. But I don't understand the little phrase, as say, second to third line, and I don't understand the last bit either.
I think we ought to look back at Medstead again, and I think that one finds the key possibly at paragraph 45 of Lord Justice Longmore's judgment, where he refers to Bristol and West, and then at the top of the next page goes on that this statement of principle does not absolve the court from deciding the scope of the fiduciary obligations if in fact the agent has, in the light of the facts, no obligation to disclose the actual amount of commission he's paid, etc. So he is buffering fiduciary duty with scope. That may be where the judge in our case is coming from.
Yeah.
Thank you, my lady.
But then the last bit of 148, it says, unless the principal had given informed consent to the agent to act on the principal's behalf, notwithstanding or trade custom and usage, acquit the agent from specifically seeking it. Is he trying to say, is it just there's some typos somewhere? The agent is in breach unless the principal had given informed consent or
It's outside.
trade, custom and usage absolve the agent from a requirement to seek it.
Yes.
Would that be a way of
Yes.
understanding?
Yes, I think so,
Okay.
my lord.
So it's either informed consent or you need to have a trade or custom that means that the agent doesn't need to seek permission. Consent.
But my lord, I don't.
Is that what he's saying? I mean, you know, because you're placing, you know, reliance on the judge's analysis, and this is what seems to kick this scope analysis off.
It does, but it's not really dealing, in my submission, with scope. It actually dealing with informed consent.
Sorry, you took us to 149, which starts the fact that this is a question of scope.
Yes. I think, to be fair to the learned judge, I think what he's saying is 148. He is probably setting out what one would normally call informed consent. And then 149, he's saying, but this can also be a question of scope. Because we know from later on in the judgment that he found some difficulty with Medstead. And sort of said if it wasn't for Medstead, he wouldn't have decided this really on the basis of scope, but on informed consent. But he's bound by Medstead. So then from 149, he is dealing with scope. And it's very clear that he deals with it because this was how the list of issues were put before him. These were separate issues. And that they are separate issues is clear from Lord Justice Longmore in Medstead. As I've repeatedly said, the issues of scope and informed consent may lead to the same conclusion and indeed may well involve the similar considerations. But the fact of the matter is that it is clear from Medstead that it can be outside the scope to have to disclose the commission. So, my lord, my lady, 179 to 181, the learned judge distinguishes Hurstanger, and that's the style on the facts. And then paragraph 183, he follows Medstead. And as I just pointed out, in 183, here I make something of confession. Absent the close analysis of the law, which this case has demanded, I would have instinctively assumed that absent informed consent, the scope of our adjudicary's obligation extended not only to disclosure of the fact of the commission, but also the amount, which I think is really the point Lord Justice Snowden was putting to me. And Lord Justice Snowden might have some sympathy with the judge. But the judge was bound to follow Medstead, and he did. And in so doing, it can't be said by my learned friend that he somehow misapplied the law or took into consideration something he shouldn't have done. And then finally, in 194, he says, it strikes me that there would be some difficulty in holding that the scope of the agent's duty extended to disclosure of the arrangements for the funding of commission when it does not extend to disclosing the amount of the commission. However, even if that is not a problem, when questions of the amount of commission can be divorced, as I've said, Mr. Gaisley could have asked. He would have been aware that somebody must be paying its commission, Utilitywise its commission. He had no reason to believe that the defendant would be funding that out of its own resources. He apparently just assumed that, and he makes the public domain point.
So can you pull those points together for us in relation to grounds 1 and 2?
Well, this is just in relation to ground 1, my lady.
Mm-hmm.
So in relation to scope, it cannot be said that the learned judge in any way misapplied the law. He applied the law as set out in Medstead and Bowsley. And he distinguished on the facts Hurstanger and FHR. He took into account all the relevant matters. And there was nothing that he failed to take into account. And therefore, in my submission, the judgment in this respect is simply unimpeachable. You may want to say, well, if it had been left to me, I would have decided it on the basis of informed consent rather than scope. But it was open to the judge to decide it on both grounds. And there's no reason for attacking his finding on scope. My learned friend, just pick up a couple of other points. My learned friend criticises the judge because he says he was wrong not to focus on the undertaking and to focus on all these extraneous matters. But the judge answered precisely the same question as Lord Justice Longmore answered in Medstead. Did the fiduciary have a duty to inform the principal of the share or amount of the commission? And lastly on this, my own friend didn't take you to, but he referred to his hypothetical in paragraphs 30 to 32 of his skeleton. My lady, first of all, hypotheticals are always dangerous and depend on assumed facts. And here we don't have to assume any facts. The judge found them and applied them. And they included that expert tooling was happy with the price, knew, or should have known, because any other assumption was illogical, that it was included in the price, and that the commission was not exceptionally large or anything other than the customary rate. And finally, all expert tooling had to do was ask. And if it had, he found as a fact, consistent with Mr. O'Connor's evidence, it would have been told. So, my lady, in my submission, the judge was quite entitled to find that the scope of the duty did not extend to disclosing the amount of the commission. So, my lady, if I can move on to ground 2, informed consent. Of course, it's academic if I'm right on ground 1.
Well, it's exactly the same question.
It is.
Both, so.
It is, absolutely. And the judge recognised that in paragraph 215 of the judgment, where he said, as I've said, there is a very significant overlap between issues of informed consent and issues of scope. Largely the same case law is germane to both. Now, in our submission, the judge correctly identified the requirements for a principal to give informed consent. First of all, foreknowledge of all material circumstances, that's paragraph 216, to bring home the potential conflict of interest, that's paragraph 217. And the judge applied Hurstanger, although he distinguished it on the facts and distinguished FHR. And he also applied His Honour Judge Headley's other criteria set out in paragraph 78 of the judgment in Leicester Bowles. And my lady, I ask, perhaps it's a jury point, but the best test for materiality is what the principal wanted to know. And here, and one can see this, we'll go back and look at the transcript, the telephone transcript. Mr. Jackson said, if you've got any queries, call me or your account manager. Here's my number. And I've already addressed your ladyship on what expert tooling was told. As a matter of principle, a principal cannot deny knowledge because he was told something, but ignored it, or didn't hear it, or didn't understand it. Or if he held an illogical assumption about it. And in that respect, my lady, I just point out, we don't need to turn it up, paragraph 42 of Hurstanger, where Lord Justice Tuckey, talking about the notification that was given in that case, he says that the principal must be taken to have understood what was said. And that must be right. In paragraph 27 of our skeleton, we make the point that what constitutes fully informed consent is a question of fact. and we refer to various authorities in the footnote. Can I just invite your ladyship to look at Maguire against Macaronis, which is in the authorities bundle, tab 18. At page 315 of the bundle numbering. Thirdly, in the circumstances disclosed above, if the appellants were to escape the stigma of an adverse finding of breach of fiduciary duty with consequent remedies, it was for them to show by way of defence informed consent by the respondents to the appellants acting in relation to the mortgage with a divided loyalty. What is required for a fully formed consent is a question of fact in all the circumstances of each case, and there is no precise formula which will determine in all circumstances if fully formed consent has been given. The circumstances of the case may include, as they would have here, the importance of obtaining independent skills advice from a third party.
And this is an Australian case.
It is, my lady. And then tab 26.
I'm not sure, I mean, with all due respect, I'm not sure, I think they've truncated a point. I mean, what is, it certainly is fact dependent as to whether there has been fully informed consent, but the question of whether something is fully informed consent is a legal test.
Yes, and that's the test that His Honour Judge Saffman sets out in 216 and 270. Foreknowledge of all material circumstances to bring home the potential conflict of interest. That's the test he applied. If we can look at an English authority, FHR at first instance is tab 26. And it's paragraphs 81 and 82, which is page 551 of the bundle.
Just out of interest, going back to ground one, at the end of the paragraph, you just referred us to the High Court of Australia certainly reiterating so this is the more conventional approach. It's the existence of informed consent goes to negate what would otherwise be a breach of duty. They don't talk about, they say that there's no duty on the appellants to obtain informed consent. In other words, they don't treat informed consent as part of duty.
No, my lord, and I accept, I think I accept what your lordship says about the conventional approach.
Yeah, okay.
But one still has a decision of a trial judge following a Court of Appeal decision. I fully accept taking into account all similar considerations, and you can tell me till the cows come home, it doesn't matter, Mr. Lord, you can give up ground one, but I don't think I can, because it's there in the judgment, and it follows Lord Justice Longmore in Medstead. And Medstead is binding. But there we are.
Just to follow up the question, the point about whether this matters,
Yes.
and the overlap, I think your case would have to be, wouldn't it, that wherever there is informed consent to satisfy that test, the scope of the duty is curtailed.
I'm not sure it would have to be that, but it would be unattractive for it not to be. I mean, I think it would follow that if there was, it might not, on particular facts, if you had an unsophisticated and vulnerable principal who was told about a conflict in a general way, but didn't appreciate what was going on. One can see that one might say there, well, the duty is still a full duty of disclosure, and you must disclose everything.
I thought the distinction between some of the cases we're showing us as to whether it was or wasn't within scope is the vulnerability or sophistication of the principal.
It is. It is. So that's what I'm saying. So you have a vulnerable and unsophisticated principal. So you take that into consideration on scope, and you say, well, there we are. The scope is not. It does include disclosing the amount of the commission. But on the facts of the case, the amount of the commission was disclosed. It is just that this principal didn't pay any attention to it or didn't heed it, in which case you would still find that there was informed consent. But it depends how the facts play out. Lady, I was taking you to Mr. Justice,
81.
Simon, page 551, paragraph 81. Since the sufficiency of disclosure is dependent on the facts of particular cases, previous decisions will be of limited assistance. However, it is convenient at this stage to refer to a line of cases referred to by the defendant. 1. There may be circumstances in which the payment of commission is wholly immaterial since it does not give rise to a conflict. And in cases in which a conflict an interest and duty may arise, where the principal knows the agent will receive a commission and could have discovered what the commission was, but did not take the trouble to inquire, a misapprehension as to the amount of the commission will not mean that there has been no informed consent. See Great Western and Barring v. Stanton. 3. The court will not regard there being a lack of consent where the principal knows that commission will be paid, but wrongly assumes that it is an annual retainer rather than the standard and usual brokerage. The latter two categories illustrate a consistent approach, where the agent can show a customary usage or that the amount of the commission is standard and ascertainable on inquiry. The failure of the principal to make inquiries as to the amount of the commission is fatal to a contention that there has been insufficient disclosure. So, my lady, I rely upon that as being entirely appropriate to our case. Here, paragraph 181, there was nothing unusual about the amount of the commission.
Well, the judge said he hadn't been shown any evidence to suggest that. But
Yes.
this is putting it the other way. There wasn't any evidence. This was in fact standard, was it?
Well, there were various annual rates of commission that were put to Mr. O'Connor. The judge doesn't refer to them in his judgment, but that were put to Mr. O'Connor in evidence. And so the judge had that. But you're right, he does put it the other way around. There was nothing to suggest. But there we are.
Was the amount of the commission ascertainable on inquiry?
Yes, he did. Because he said all they ever had to do was ask.
Well, hang on. Who said all they
The judge and Mr. O'Connor.
And so, what? Who would they have asked?
Utilitywise. And Mr. Jackson said, ask me. If you want to know anything, ask me. Have you got any queries?
I'm sorry to interrupt, my lord. Mr. Lord, he said to the court that Mr. O'Connor had put to him general rates of commission.
Yeah.
I've reread Mr. O'Connor's commission. I may have got it wrong, may have missed it, but I think if my learned friend wishes to persist in that submission, he should actually identify which passages he's referring to, because I don't remember them. I may have missed it, but I don't remember.
I can find it. If one goes to, it must be in the supplemental bundle. And it's the cross-examination. Of Mr. O'Connor. Oh, can I just, the transcriber has asked for a 5-minute break, which I could usefully use.
On the basis that it is convenient to you also, yes, but not generally because we're very short of time.
I understand.
And also in that regard, obviously this is all essential and very interesting, but we're only on round 2. 5 minutes.
Rise if they will.
Yes, yes.
This isn't original. So I think these are solid from people achieve it. Did you really? I thought perhaps you were doing a Tom and having a wig of a great. Oh no. Is that? Yeah, Jeremy Hutch. That's why the thing on his head looks disgusting. It looks like just some sort of rat or squirrel on his head. But it's Jeremy Hutchinson. Yeah. If I pick it out once a year. Okay. Let's do that. So there's always someone in chambers who's not in court. It's deductible. You get to hand it down at the end of the day. You think of the junior who one day will receive St. Davis's. I'm not thinking about that. I think you should think about that. It's Davis, isn't it? Is it Davis or Davies? In Australia we would say Davies rather than Davis, but people here so often say Davis, so I just assume. Yeah. I mean, all those things are worth thinking. Which do you prefer? I don't think about it. I'd say both. I say both. To highlight. So, we talked to the PhD students last week. I said to introduce themselves because they got just answer.
Keep forgetting that.
It's like, well, what do you want me to call you? I'll call you who you want to. This is humanities. I just think Hugh's not in court this week, probably, so I had to see Hugh. So that's it down as well. Can't wait. At least then I had to go to someone else and sort of say, you in court this week. Say, okay, or you okay? So, what do you do? That is incredibly kind of you to give me bail. Chancery stuff. So we've got a chancery stuff.
Is court ready?
Mr. Lord, where were we?
Thank you, my lady, and perhaps thank you to the transcriber for
Yes.
giving me those 5 minutes. In the cross-examination of Mr. O'Connor, supplemental bundle, page 91, the UK non-domestic electricity 2016 figures were put to him. But I think, from recollection, what he was cross-examined about actually were the unit rates, not the commissions. But that's the evidence that was before the judge. And you've seen what he says in paragraph 181. And I entirely accept what Lord Justice Zacaroli put to me, that one has to put it the right way round, that there was no evidence that the commission was an exceptionally large sum or anything other than the customary rate. So that's where we are in relation to that. My lady, we've just been looking at Mr. Justice Simon in FHR, and in my submission, his observations are entirely appropriate to our case. Here, expert Tooling knew that Utilitywise would receive a commission, and could have discovered with reasonable inquiry what it was, and they would have been told. That's what the judge found in 119 to 126. Therefore, there was informed consent, or to go over the page, paragraph 82, where it can be shown that the amount of the commission is standard and ascertainable on inquiry, the failure to make an inquiry is fatal. And all of that's for good reason. And my lady, as well as Maguire and FHR, one has my own friend in paragraph 53 of his skeleton. He recognises that whether the measure given is sufficient to permit informed consent turns on the particular facts of the case. Yes, it does. And there's no appeal from the judge's findings of fact. And as we can see from looking at the judgment, it can't be said that the judge misapplied the law in any way.
So can I just... The finding at 119 was to do with intentional concealment.
Yes. Yes, but it's a finding that there is no reason to believe it would not have been told. And that's consistent with what Mr. O'Connor told the court, supplemental bundle 82C, 87F. And then 126, it seems to me that the amount of commission and how and by whom it would be paid could have been discovered by a simple request by the claimant. So, my lady, in those circumstances, in my submission, the judge was quite right to find that there was informed consent. And because my learned friend can't point to any mistake as to law, he is in effect driven to appealing the judge's factual findings. So he's driven to say that Mr. Forster and Mr. Gaisley were not sophisticated and were vulnerable. And then finally, my lady, in relation to this ground, in discussion yesterday, Lord Justice Snowden identified two matters that might not have been disclosed and therefore not consented to. First of all, that expert tooling was not told that it would be recharged to it. But in my submission, they were told. They were told, I don't want to get back into the debate about the telephone calls, but one has what was said in the telephone transcripts. But they were told on the face of each and every one of the transcripts. And
On each and every one of
sorry,
the
every one of the contracts.
contracts.
Sorry, my lady. And any assumption.
What were they told? May?
May. Yes. But then you add that to what's said in the telephone transcripts, and you add in what the Court of Appeal say in paragraph 84 of Hursthanger, where if they're not paying you, if you're not paying them, you should assume that the other side are paying them.
That's Johnson, I think.
That's Johnson, paragraph 84.
That's different, isn't it? That's the other side, i.e. in this case, Engie would be paying, because you're not paying the agent to do the work for you, therefore the other side must be.
Therefore, Engie will be funding it. Yes.
No, I thought it was.
Well, paying them. Yes, you're right.
Yeah.
Yes. And then you have the judge's point that why else were they even told about the commission if it was a matter?
Because it's an obligation of a fiduciary to tell to give information about that.
That was first of Lord Justice Snowden's matters, and the second one was the campaign commissions, which I hope I've explained are irrelevant. My learned friend then sought to add two others. First of all, that the agent set his own commission, and he said that's similar to the DIC contracts in Johnson. But that's not relevant. What is relevant is what the unit rate was, because that is what the customer was concerned about. How much am I going to have to pay for this electricity? And that they were told and they were happy with. And the second point raised by Mr. Grant.
Is that right? If I ask you to go out into market as my agent and find the best price for an energy contract, if I'm told by you I'll be paid a commission by the energy company and it's a standard rate, it's an industry standard that pretty much every energy company has settled on, my attitude might be very different to that, as opposed to knowing that in fact it's not an industry standard rate, but it's just a number that you, my agent, has fixed for yourself.
Well, I repeat, my lord, what matters to the customer is the bottom line. What have I got to pay? The other side of it, what matters to the customer is what am I getting? And I'm getting energy.
But don't forget, the whole concept of this, underlying this, is that the principal has to give consent to the agent acting for him and representing him and signing him up to contract in a particular circumstance. And what the principal in all fiduciary relationships has to do is to evaluate whether he has the undivided loyalty of his fiduciary, and to the extent to which he doesn't have the undivided loyalty, whether he's nevertheless entitled to take the risk that involves. Well, it's not just a question of the pounds and pence. You do need to know a little bit more about whether the nature of the commission affects the loyalty of your agent. If it's the same commission that everybody will get, if it's the same commission that will be offered by every energy company, then in a sense, your agent will still be loyal, because he can, doesn't matter where, he will still try and get the best price from you, even though he's getting the industry standard commission. If company X allows him to fix his own commission and company Y doesn't, I would need to be told that, because then I would be able to evaluate the recommendation that he would give me to go with X rather than Y, surely. I mean,
You would only need to be told that if, A, you were not happy with the price you were being asked to pay, and secondly, it was exceptionally large.
Well, no, I mean, the point is I am entitled to start from the assumption that my agent is going to get me the best price reasonably obtainable. It's not a question of whether I'm happy with it. My assumption, if I ask an agent to go into the market, is he's going to get me the best price reasonably obtainable, not just one that I'm, quotes, happy with. I'm only happy if it's the best price.
Yes, but my lord, this is not a mis-selling case. This is not about what was charged. It is about the commission, and only about the commission. And as far as expert tooling is concerned, it knows, or should know, any other assumption is illogical, that it is paying or funding the commission as part of the unit rate. If it wants to know precisely what the commission is, or if it wants to know the precise circumstances in which it's been worked out, what additional services were being provided, and how did you attribute that, it had to ask. It only had to ask, and it would have been told. Otherwise, you're getting very close to, and I accept we're in the realms of fiduciaries, but to say that a broker, an agent, must disclose absolutely everything. Because if he, you raise your eyebrows.
Well, everything material.
Yes. If it,
Well, is that such a, sorry, is the proposition that a fiduciary agent has to disclose everything material, is that quite so revolutionary?
No, everything that is material. But what is material in this case is how much are they paying for their electricity. They know that.
The problem with that is that it's, you say they were happy. They'd have been much happier if they'd got a penny or two off the kilowatt hour rate, wouldn't they? And if that, the difference between this supplier and another was because this, let's assume another supplier was willing to supply electricity to them at the same price. That doesn't mean that's the end of the matter, because this supplier might have been perfectly happy to provide it at a lower price on the basis that the commission paid to the agent was less.
Yes, and I mean, there's evidence from Mr. O'Connor in his witness statement where he says that the lowest price isn't necessarily the best price because of the status of the supplier, because of the additional services. There's all sorts of things to factor in. But when one is considering here...
No, but I'm not sure that's the point that my lord's just been putting to you, unless I've missed the point. The point he's putting to you is that just assume this supplier, Tooling expert Tooling would have been far happier to receive the same energy but with at a lower cost if the agent hadn't been fixing its own commission at the level it was. That's what it wasn't told was happening.
Yes, but the question is that material? And I know I'm just repeating to my lordship the question you put to me. And my answer to it is no. What is material is what you're paying. And as long as you are happy with that, you are happy. You may not be as happy as in Lord Justice Zacaroli's world, where you've got it 2 pence cheaper, but you are still happy. And if you want to know any more, if you want to know what it is, then you have to ask. If you want to know how it's been calculated and how it's referable to the additional services that you've been told you're getting, then you have to ask. But my lord, two matters that Mr. Grant added. His second one was that if you entered into a contract for a longer period, you get more commission. Well, my lord, first of all, that's obvious. And if Mr. Forster or Mr. Gazey had thought about it, they must have realised it. Because they knew. They knew the first contract was for a very long period, 5 years or something. So there's nothing that's not disclosed there. And there's obviously, to some extent, there's an attraction in locking in the rates for a long period of time. There's nothing wrong, per se, with long contracts. And they may be beneficial. Nobody could have foreseen that there was going to be a war in Ukraine and the effect that would have on energy prices. So if you have a contract for 5 years and you know you're getting a contract for 5 years, and you know, or should know, that you are paying commission as part of your unit rate, you will know that you are paying commission for 5 years. It's nothing that hasn't been disclosed. So, my lady, in conclusion, in relation to ground 2, in our submission, the judge did consider all the relevant matters and clearly had all the cases in mind and the law in mind, and was careful. He distinguished Herstanger and McWilliam on the facts, so it can't be said that he misapplied the law in any way. And as Mr. Justice Simon makes clear in the Australian case, these are questions of fact. And I repeat, my lady, these are matters, informed consent, and the question of informed consent is preeminently a matter for a trial judge. And we've heard, there's hundreds of these cases. And God forbid that they all think that they can come along to the Court of Appeal and say, we didn't like the judge's conclusion on informed consent. They can say that if they can say, because this judge completely ignored Herstanger, completely ignored McWilliam, completely misapplied the law, that's fine. But that's not this case. This judge took into consideration all the relevant matters, applied and recites this, applied the law correctly, and one simply cannot say, and it would not be a proper function of an appellate court to say, we're going to revisit that. My lady, ground 3, which is the judge erred in law in his approach to sophistication and vulnerability as a basis to distinguish Herstanger. I've covered this to a very large extent. In paragraph 48 of my learned friend Skeleton, which is page 33 of the core bundle, it's accepted that McWilliam and Herstanger demonstrate that the sophistication and vulnerability of a person may be relevant in determining what constitutes informed consent and whether disclosure of the amount of the commission was required for that purpose. And that must be right. And I just repeat, the judge's conclusions are not conclusions on sophistication and vulnerability that no reasonable judge could have made. Compare the position of expert tooling with all of its employees and its turnover, and its accounts are in the bundle and all of that, with the pub lady, landlady in the dark blue pig, or the gentleman who was acting on behalf of the Lawn Bowls Club, gratis. So, my lady, there's simply no reason for revisiting the judge's findings on sophistication and vulnerability. Ground 4, to the extent that the judge relied on trade custom or usage as part of his analysis, he plainly erred in law. Well, my lord, my lady, the short answer to that is he didn't. And we didn't urge him to. The references for your note, the fact sheet, he was certainly told where it was, is in the supplemental bundle at page 336. And it describes how it's calculated as part of the unit rate. And then it's referred to in paragraph 100 of the judgment, where he summarises its findings, as he does in 101. Then in 187, he says, he adds, not only that, the fact that often happened was in the public domain, and he refers to the fact sheet. And then in 195, talking about expert tooling, he apparently just assumed that even though it was in the public domain, that is often not what happens, about the illogicality of it. And then 199, furthermore, the assumption that commission will be funded by the defendant is not supported by information in the public domain. And those are the only occasions when he refers to it. And then, paragraph 225 of the judgment, I would add that in coming to my conclusion that there was sufficient disclosure, it is right to note that the fact that commission was added to the unit cost was a known industry practice, which is referred to in the fact sheet to which I've already referred. To that extent, insofar as it reflects trade usage and custom, it actually obviates the need for specific informed consent because the principal is taken to know of the trade custom and to have consent. Insofar as it is not a trade custom, it is simply another brick in the wall erected by the defendant to defeat the claimant's case. And that's how I put it, and how I put it because it is just another brick in the wall.
So you didn't suggest it's a trade
No,
custom?
never suggested that there was a trade custom or usage. And in my submission, the judge doesn't find that there was. He just refers to it as another brick in the wall.
I know, well, if it was your phrase, I didn't quite...
It wasn't my phrase.
Oh, okay.
No,
But
it wasn't my
another
phrase.
brick in the wall. I mean, is it...
It's not a good metaphor.
No, because brick in the wall is normally something that does amount to an obstacle.
I know. I know, I agree.
Okay.
It's not my metaphor, I should make clear.
Okay.
So, my lady, that's ground 4, which I don't think need trouble anybody for going on. Now, ground 5
if you'd have said it's straw brick or something like that,
Good sense.
that's what would have made a bit more sense. If you, what you're saying is that last sentence is just it's dismissing it, I think.
I think what he's saying is when one is considering what they knew and perhaps what they should have known because of their illogical assumptions or whatever, he's gaining a little bit of comfort, not that it really forms any significant part of his decision, to the fact that there is this fact sheet out there, which Mr. Gaisley and Mr. Forster said they didn't see, which we couldn't say and didn't say we showed to them or drew to their attention. But it's out there in the public domain that as a matter of, whatever words one wants to use, as a matter of practice, trade custom or whatever, but he wasn't finding a trade custom, that this is how a lot of these TPIs or brokers are paid. That's all. So, my lady, ground 5.
Yes.
The judge erred in law in deciding that dishonesty was required for the supplier to be liable. And in any event, that argument was not open to the supplier. So there are two issues. Was it open to us to argue it? Secondly, is it required? The requirement for dishonesty was an argument that was open to us. There was no ambush. What happened is expert tooling eschewed such a case and denied it was required. So stepping back in time, it was not pleaded, and we've looked at the pleading, and yes, dishonesty is not pleaded. And Mr. Grant said, oh, well, the facts are there that are sufficient. They're not. It was not pleaded as it should have been, and the authorities are well known to my lady, but they're in the bundle. We raised the point, I accept, just before trial, making it clear that we were going to run the point, that dishonesty was required. And expert tooling accepted that. They didn't seek an adjournment. They didn't say they needed time to deal with it. They simply said, dishonesty forms no part of our case, and it is not a legal requirement. And then, quite properly, during the evidence, no case based on dishonesty was put to Mr. O'Connor.
Was Mr. O'Connor, I should know this, I'm sure, but was he involved in the transactions at the time?
He wasn't. He was a sales. What was he? He was a sales director or something
Yes,
of
I've
that
seen
kind,
what he
as
says
a
he
kind.
was.
But he wasn't involved in these contracts. No.
So would his knowledge have been relevant to a claim in dishonesty?
Well, perhaps not. And it would have been open to expert tooling, Mr. Brown, who was then appearing, to say, well, if this is going to be raised, we would have then had what would have happened is we would have had a debate before the judge as to whether or not they could in effect say, we want to run a case based on dishonesty. Because my position would have been, it's not pleaded, nobody's prepared for it, and you can't.
Yeah, I mean, what you'd say is that if correctly analysed, dishonesty is a part of the cause of action, an essential part of the cause of action, then it's for the claimant to plead it and to identify the person, the human person, at the defendants whose knowledge is attributable to the company for the purpose of saying that what happened was dishonest, because you've got to start from the proposition of who knew something. And with a corporate entity, it's quite important not to fall into the trap of aggregation.
Yes.
I had this discussion yesterday. You can't say, well, Mr. A knew this, Miss B knew that, therefore the company knew this and that, ergo it's dishonest for them to have done something. That's a fallacy. There are quite a few cases on that. I can't remember off the top of my head. Hampshire Land, I think, may be one of them. But in any event, that's why you normally plead dishonesty if it's an essential part of the cause of action, and it gives the defendant the opportunity to then
Identify.
put the person up, if it, or to admit, yes, they knew, and that their knowledge is attributable to the government.
Yes, I mean, if Mr. Brown had said he wanted to run dishonesty, we would have said you can't. Look at your pleading; it's wholly inadequate. Now, the judge might have said at that stage, "Well, we're going to have to adjourn," and he would have ordered expert tooling to produce a new pleading, properly setting out the allegations of dishonesty, in respect of which we may or may not wanted further and better particulars. But then, your lordship's absolutely right. We would have had to consider who are we going to put up to defend this claim of dishonesty. Now we know what it is, and we know what it is we have to meet. But none of that happened, because Mr. Brown adopted the same position indeed as Mr. Grant, although in a slightly different way, and he simply said dishonesty is not required, and it is no part of the cause of action for procuring a breach of contract claiming equitable compensation. So, yes, the answer to the first point is, was it open to us to raise the point? Absolutely. And having raised it, it might have been open to the claimant to say, well, we need to go away and reconsider that. But as Mr. Grant acknowledged to Lady Justice Asplin, no adjournment was sought. So we simply proceeded on the basis that there was no claim or allegation based on dishonesty before the court, and it wasn't put to Mr. O'Connor. And as Lord Justice Zacaroli says, he may not have been the right person anyway. So that's the answer to the first point. As far as whether or not dishonesty was required, in our submission, yes, it plainly is. As far as all the authorities are concerned, yes, it's right that at the time we were focusing on...
Are you going to come back to ground 8, or is that your answer to ground 8?
No, I'm going to come back to ground 8. I'm dealing with ground 5.
Well, I know you are, but in a sense, we've just been having a little digression, which in a sense is...
No, I am going to come...
As long as you're going to come back to it, that's fine. So
as far as dishonesty was required, yes, we did focus on Twin Sector, and yes, that's in our skeleton, and yes, the world's moved on since Twin Sector. And I don't think there's anything between us as to what the test is. If we can just look, first of all, at Royal Brunei.
Before we do that, could we just step back one moment? What was actually being run? Because some things were not run, that some causes of action. What, in the end, was being said that dishonesty was not required for? I know it's been said, but I just want to
first
be
of all,
clear.
Procuring breach of duty, procuring a breach of fiduciary
So
duty.
the use then before the judge was of procuring. Okay.
Yes. So it was Mr. Brown was basing it on Hurstanger, and he wasn't putting it on the basis that Mr. Grant now puts it. He was saying they are liable, they being the supplier, for procuring a breach of duty. So that there had to be a fiduciary duty, there had to be a breach of it, but dishonesty was not a requirement. And he focused on the passage in Hurstanger, I can't remember if it's 34 or 36, where it acknowledged that the person is an agent. And he said that's all that's required. He also pleaded and he ran a case based on inducing a breach of contract. And we cited OBG and all those cases and said there must be intention. And the judge deals with it in his judgment. But it wasn't really, I hope I'm being fair to Mr. Brown, as the judge puts in his judgment, it was very much feeling that inducing breach of contract didn't really add anything to procuring a breach of duty. And that's how it was run at trial, but now the tortious claim for inducing a breach of contract is not being pursued.
Thank you.
Can we look at Royal Brunei, which is in Authorities Bundle, tab 13. And dishonesty is considered on page 227. And I think I'm just going to give your ladyship the references because these will all be well known to you. So it's 227 over to 229, where it sets out that it's an objective standard. But just while we're here, why I wanted to go in part to Royal Brunei is on page 224 at letter E. His Lordship says, to resolve this issue, it is necessary to take an overall look at the accessory liability principle. The conclusion cannot be reached on the nature of the breach of trust which may trigger accessory liability without at the same time considering the other ingredients, including in particular the state of mind of the third party. It is not necessary, however, to look even more widely and consider the essential ingredients of recipient liability. The issue of this appeal concerns only the accessory liability principle. Different considerations apply to the two heads of liability. Recipient liability is restitution-based. Accessory liability is not. And, my lady, that's important in connection with some of the submissions my learned friend made about what the cause of action is, and possibly even in relation to in relation to limitation. Because it is not a restitutionary-based liability. And a lot of the cases that my learned friend took you to or referred you to are restitution cases. My lady, we'll come back to that. We won't actually come back to it, but having referred you to it, you know what it says. So, my lady, just for your note, Barlow Klaus is tab 22, and we would refer you to paragraphs 14 to 18 in Barlow Klaus. And Ivy, which I don't think it refers to in the judgment, but the judge referred to Ivy in the course of our closing submissions. Ivy is tab 30, page 650, and the relevant paragraphs are really 62 and 74. And then group 7 is tab 38. And in group 7, as my ladyship will recall, all the authorities really are gone through in paragraphs 33 to 58, including the passage of Lord Hoffman clarifying in Barlow Klaus what he meant in twin sectra. And then 59 to 61 deal with blind eye knowledge, and we may just have a look at that when we come on to ground 8. Then can we turn, I think we do need to look at Hursthanger. And that is in tab 23. And a couple of preliminary points. The issue of a secret commission only arose by way of amendment at trial. One sees that in paragraph 30. And written submissions on the applicable law and its application to the facts of the case were only supplied after the hearing. That's referred to in paragraph 32. Now, as we saw yesterday, in paragraph 34, reference is made by Lord Justice Tucky to an accessory. So that in my submission is the cause of action he has in mind, accessory liability. Just in passing, because this is really relevant only to ground one, but paragraph 36, the passage from Bousted is repeated, and we looked at that earlier. Now, my lady, in my submission, one needs to be clear when Lord Justice Tuckey, this is all under the heading secret commission, one needs to be clear when he is talking about secret commissions and what he calls the halfway house. And in paragraph 38, he's talking about bribes and secret commissions. And he's distinguishing then, paragraph 39, third line, is there a halfway house? So now he is going on to distinguish between a bribe or a secret commission and his halfway house. And in paragraphs 40 to 42, he considers the disclosure and whether or not it was adequate. In paragraph 43, he considers whether that disclosure negates secrecy. And in paragraph 44, he considers whether or not the defendant's informed consent was obtained. And then, paragraph 45. So for these reasons, I do not accept either party's submissions about the disclosure. This is a halfway house case. The claimant did not pay the broker a secret commission, but procured the broker's breach of fiduciary duty by failing to obtain the defendant's informed consent to the broker acting in the way he did. But there is no, and with the greatest respect to Lord Justice Tuckey, there is no analysis as to why a failure to obtain the defendant's informed consent meant that the claimant had procured the breach of duty. How could it? One asks rhetorically. I mean, there's no, in our case, there's no contact at all between the supplier and the customer. And if one steps back, if there was informed consent, there would be no breach of duty. But if a failure, a simple failure to obtain informed consent by the broker would be sufficient to make a third party liable for procuring a breach of duty, then there would be no distinction between the liability of the recipient of the commission, who was a breach of duty, and the accessory liability of the payer of the commission, who didn't owe any duty at all.
Could that last sentence of 45 be read? The claimant did not pay the broker a secret commission, but procured the broker's breach of fiduciary duty, and then the next words are just a description of the broker's breach of fiduciary duty. Is that right? Either the broker breached his fiduciary duty by failing to obtain the defendant's informed consent to the broker acting in the way he did. In other words, the by failing refers to what the broker didn't do, rather than what the
Yes.
That's the breach of fiduciary duty.
defendant didn't do.
So in that circumstance, my Lord Justice Snowden, I repeat what I just said, that there is no analysis as to why the broker's failure to obtain informed consent meant that, in this case, the claimant, but meant that the third party had procured a breach of duty. There is simply no analysis of it.
Yeah, but he's not. Sorry, maybe I've misunderstood the point you're making. All I'm saying is he's simply saying this isn't a secret commission case.
Yes.
It's a procurement case where the breach of duty was by the broker who failed to obtain the defendant's informed consent to him acting in the way he did. Right.
Yeah, you may well be right, my Lord, because it's the point I'm making.
He's not trying to say any more than that, is
No,
he?
so he's not addressing at all the ingredients
Of the
of the
liability.
accessory liability.
No, he's not.
No.
Not at all. And one has to remember how this developed, being made by way of amendment at trial, no submissions on it, later written submissions. And Twin Sector, or any of those cases, none of them were cited.
No, he's been dealing with a big passage about secrecy. Is this secret? Is it not
Yeah.
secret?
Yes.
And then he just says, no, it's not, it's a halfway house. It's a half secret.
Yeah, and therefore the broker, as your lordship's pointed out, the broker was in breach of fiduciary duty. Not saying anything about the third party. He then, though, goes on.
Other than the cases, a procurement case.
Yes, yes.
It's procuring a breach of
It's
fiduciary
procuring,
duty.
and don't forget he's mentioned the word accessory earlier. Not that probably adds much.
Yeah, and in Royal Brunei and Tan, procurement was expressly said to be part of accessory liability.
Yes. 46. This conclusion that means that the defendants are not entitled to deploy the full armoury of remedies. And so he then goes on, everything else he says is concerned solely with remedies. He doesn't go back to revisit the unanswered question of what makes the third party liable. And so if one looks at 48, in Johnson's case, the court ordered the solicitor to account for the service charged to his client. In this case, the broker could similarly have been required to account to the defendants for the £240 commission he received from the claimant. But no such claim has been made against the broker, and so alternatively, the defendants have a claim for equitable compensation against the claimant as it procured the broker's breach of fiduciary duty. But there he is reaching the conclusion, but he doesn't explain why. And then he goes on with the passage that my learned friend likes so much. This mirrors the common law right to claim the return of a bribe as money had and received. But he is not saying there that the ingredients of the quite separate causes of action for bribery and those causes of action in equity for equitable compensation as accessory liability mirror each other. Rather, all he's saying is that if liability is established, the remedies do. And that's the point we make at the end of paragraph 3 of our skeleton. And that's why I referred your ladyship to the passage in Lord Nicholls' judgment in Royal Brunei, where he explains that recipient liability is restitutionary based, but accessory liability is not. A common law liability for money had and received can be said to be restitutionary based. But accessory liability is not, save when one is considering or focusing, as in my submission Lord Justice Tuckey is here, solely on the remedy. So, my lady, in our submission, it's understandable why Lord Justice Tuckey dealt with it as he did, because of the way in which it arose, the fact the authorities, the relevant authorities, Twin Sector, etc., were not cited to him, and I can adopt my learned friend's refrain in relation to Medstead. The actual outcome is fully understandable, but what this doesn't help us with at all.
Sorry, just pausing a second. The word return is a curious word, isn't it?
The word return?
Yeah, in that sentence.
Yes.
Because I think we saw that as against the briber, the claim in common law is postulated upon a fiction, an irrebuttable fiction, that the amount of the bribe which was paid by the briber to the bribee, the agent, was directly reflected in an increased cost to the claimant. And the claimant doesn't recover the bribe because he never got it. What he recovers is the assumed overcharge, which may have funded the bribe if you know, to be paid. So it is in fact looking at what the claimant lost, namely, or the damage which he suffered, which was the overcharge. And so, if you've got a claim for compensation, it's a little bit sort of truncated what's said here, but in many ways it is a sort of compensatory
Yes.
approach. I mean, I think that's what he's maybe driving at with that last sentence.
Yeah, and it works for equitable compensation. One doesn't have to do or have to adopt the irrebuttable presumption if one's simply making a claim for equitable compensation.
Yeah, the compensation is that the claimant has actually, so there's something very wrong with that sentence anyway, which I've just seen. It's the claimants have a claim for equitable compensation against the defendant, don't they? Or maybe in this case it was the other way
No,
around.
it is the other way round.
Some curiosity, but in normal circumstances, the claimant says, I want equitable compensation because you bribed my agent. The compensation I want is for having presumably overpaid. You maybe can't rely upon a presumption, but you could demonstrate on the evidence that you suffered loss because you overpaid on the contract.
Yeah.
And that's what the common law has also been fictionally suggesting by way of a claim for money had and received.
And that's the mirror.
That's the mirror.
That's the mirror, only in relation to the remedy. Whereas Mr. Grant would say he would hold the mirror up to all the ingredients of liability. And in so doing, he says it's not even an accessory liability, it's a primary liability. It's a joint and several primary liability with the person who received the bribe. And it doesn't require proof of anything more than what is required in the case of a secret commission. Now, that is plainly not what Lord Justice Tuckey is considering, because he is drawing, in 3839, he's drawing the distinction. This is not a bribe, this is a halfway house.
He spends a lot of time drawing the distinction between full on and halfway house, and he also expressly refers to this being an accessory liability at 34.
Yes, it does. And one gets more of the same from Lord Justice David Richards in Wood. Because in Wood, we were primarily concerned with secret commissions. And the big issue, as I think I touched on earlier, the big issue was whether or not, in order to found a claim for a secret commission, you had to establish a fiduciary duty. And I submitted that you did. But following a very careful analysis of all of the authorities, including Grant and most of the authorities that my learned friend took you to about bribes, the court concluded that you didn't. For a bribe, there does not have to be a fiduciary duty. Now, for the reasons Lord Justice Snowden put to me earlier, most cases there will be anyway. But there simply has to be a duty of loyalty and a duty to give disinterested advice.
I mean, the duty of loyalty is said to be the core element of a fiduciary. It's slightly difficult to understand why you might have somebody who has a duty of loyalty who isn't a fiduciary, but you know, maybe that's just interesting conceptual point. But you're saying you can technically bribe somebody who isn't a fiduciary. That's
apparently. Yes, I think conceptually you can. Yeah. Now, I don't understand, and here correct me if I'm wrong, but I didn't understand Mr. Grant to go so far as to say that in a half-secret case, or halfway house, or partial disclosure case, whatever one wants to call it, you do not have to show a fiduciary duty. I didn't understand him to say that, but he sort of got close to it.
Actually, you might be able to, sorry, just going back, you might be able to bribe somebody who's not a fiduciary. If I engage somebody to write me a report on the market, they may well owe me a duty of care in the production of the report.
Yes.
Just saying, you know, what's available in the market, but they're not my fiduciary. I don't authorise them to act on my behalf. But you get to know that that's what the person is doing, and you bribe them to put their recommendation in to say that you're the best.
Yeah. Yeah.
That's a bribe.
And actionable as under the
As a
tort of
bribe,
bribery.
because
Yeah.
it's corrupt. But it's bribing somebody who isn't actually my fiduciary, but he's providing me with advice, and that may not be a fiduciary relationship. Maybe just one governed by contract and negligence. Possibly. Okay.
Okay, just in case I've misunderstood and Mr. Grant is saying that there doesn't even need to be a fiduciary relationship, can I just give your ladyship, we've looked at Hurstanger. McWilliam also makes it clear that there has to be a fiduciary relationship at paragraphs 43, 44. Medstead, Lord Justice Longmore does, paragraphs 29 and 32. And Wood, in the Court of Appeal, Lord Justice David Richards refers to Hurstanger at 80, McWilliam at 84, Medstead at 88, and his conclusion is at 100. So there is a formidable bank of Court of Appeal authority in support of the proposition that where there is partial disclosure, the identification of a fiduciary relationship is necessary. So, my lord, my lady, with the greatest respect, Mr. Grant is wrong when he tries to identify this new sui generis, equitable, primary cause of action. His only basis for it, because he was pressed on a couple of occasions by Lord Justice Zacaroli as to where it came from, is Hurstanger. But for the reasons we've just seen, you don't get it in Hurstanger. I fully accept that it is unfortunate that Lord Justice Tuckey was not referred to Twinsectra and other authorities, and doesn't set out the ingredients of the accessory liability of procuring a breach of duty. But he simply doesn't. But it is clear from all of the authorities we've referred to, from Twinsectra all the way through Route 7 and IB, that dishonesty is a necessary ingredient. And there is no reason whatsoever for deciding that somehow a half-secret commission case, which is still nevertheless an accessory liability case, is different from all the others. And so, in the absence of dishonesty, the principal's claim must fail.
Mr. Lord, are you going to say something about how it's all addressed in Johnson?
I was going to, yes, I am going to. I'm going to come on to Johnson because I'm dealing with the principal there, which is ground 5. So when I come to ground 8, I was going to deal with Johnson and go through Johnson in a similar manner. But I can do so now if you
It does affect round 5, doesn't it?
It does affect round 5, I think.
Well, yes, I suppose so, because ground 5 is whether or not dishonesty is an actual requirement. So,
and there is a paragraph in Johnson which says yes, but if we're wrong, and then deals with the dishonesty.
Yes. So if we turn to Johnson, which is in so it's tab 51. So, accessory liability begins paragraph 124. And paragraph 124, an explanation is given as to why it's not necessary to remit. Then 125 Hurstanger, again referring to the procuring of the breach of duty. And then it said, Hurstanger therefore seems to suggest that all that is required to establish accessory liability is to prove that the lender knew of the fiduciary relationship and paid the broker in circumstances in which, as a matter of fact, there was a failure to obtain the borrower's informed consent. Well, my lady, for the reasons I've already explained, I don't agree with that. All that can be said is that Lord Justice Tuckey does not analyse what is required to procure a breach of fiduciary duty. It then said that is a simple enough approach, although we consider with respect.
It also says that Lord Justice David Richards appears to have endorsed that. Do you happen to have the cross-reference?
No, my lord, because I don't think he did. I'll look again over the short adjournment.
Okay, but where? I mean, they must be referring back to something else in this judgment, surely.
Well, I think I assume that what was being referred to is that in Wood, which is primarily a secret commission case, David Richards is saying, but in relation to a half-secret commission, there must be a fiduciary relationship. So that's all I could work out was being referred to. But as I said, we'll look again over the short adjournment.
I think it may be paragraph 49 of Wood, my lord. Tab 42.
Well, my lady, we'll look at this more over the short adjournment. But 49 is again, it's in the realm of remedies, rather than the ingredients of the cause of action.
I think, given that I think this is quite important, it would be better to turn to it again at 2. But also, do tell me, is 2 too late? How are we doing? Do we need to squeeze a little bit more time?
My lady, I would hope that I could finish by 4 and may even finish a little bit before 4.
Okay, so we don't need to sit a little bit early. So 2 o'clock, thank you.
Fine.